Shall we begin? If I could please invite those in the back to come to their seats. It's exactly 9 o'clock by my watch, so I think we're on good time. Good morning, ladies and gentlemen. My name is Michael Moser, and to my left is the Honorable Yves Fautier. To my right, Mr. Toby Landau, QC. And next to Mr. Landau is Ms. Nathalie Segaria, who is serving as our tribunal secretary. Together, we welcome you all to today's hearing, in this case of the Renco Group, Inc. as claimant versus the Republic of Peru as respondent, and that is ICSID case number UNCT/13/1. Before we begin, if I could please invite the parties to kindly state for the record who is present for each side today. Perhaps claimant, Mr. Kehoe?
Yes, Mr. President, thank you.
you.
I'm Ed Kehoe with King & Spalding. To my left is my partner, Harry Burnett. To his left is Mr. David Weiss. To his left is Mr. Guillermo Aguilar Alvarez. At the table behind us, beginning behind Mr. Alvarez, is Ms. Jessica Bees on Croton, also with King & Spalding. Margaretta Stevens, also with King & Spalding. And then Josh Weiss and Dennis Sedlusky, who are the heads of the legal department at Renco.
Thank you. Mr. Hamilton.
Thank you very much, Mr. President and members of the tribunal. The Republic of Peru will be pleading in Spanish and English today, and I'm going to invite the Ambassador of Peru and former Minister of Economy and Finance of Peru to begin our introductions.
Thank you very much.
Mr. Ambassador.
Good morning to all. Mr. President, honorable members of the tribunal, my name is Luis Miguel Castilla. I'm the Ambassador of the Republic of Peru to the United States of America. It is an honor to be present at this hearing, and I would like to point out our total respect for the free trade agreement between the United States and Peru. I'd also like to underscore the importance given in our country to development to benefit our citizens, and with regard to investors, always with a reasonable expectation of respect for our standards. The matter has received and continues receiving respect by the Peruvian state within and beyond this international forum. On behalf of Peru, I thank you for your attention to our representatives and counsel in relation to this matter. Thank you very much, Mr. Ambassador. Members of the tribunal, I'm Jonathan Hamilton, the Latin America litigator for the legal offices of White of Case. Next to the ambassador is Mr. Carlos Jose Valderrama, President of the Commission for the Defense of the Peruvian State. Next to him, Andrea Menaker, a partner of White & Case. At the table behind, we have the legal team for the Republic of Peru, including Mr. Francisco X. Gijon, Michelle Grando, Carlos Matera, Maria del Carmen Tovar, from Estudio Echecopar of Lima, and Mr. Quijos, and we are accompanied by other representatives of White & Case and the Republic of Peru and its embassy.
All of those observers who may be joining us in the adjoining room or remotely, we extend to them a very kind welcome as well. Now, gentlemen and ladies, as you know, the purpose of today's meeting is to hear oral submissions on the issue of the waiver requirement, which is contained in Article 1018 of the treaty. And the tribunal has already benefited from your very comprehensive written submissions, for which we thank you. We have a schedule which has been agreed today. That's been very helpfully fixed now, And we do hope that we'll be able to adhere to that, which means that we have to act very efficiently so that we can stay within these time limits this morning. So before we begin, let me ask both sides whether there are any outstanding housekeeping issues which need to be dealt with. Mr.
None from
Kehoe?
the claimant, Mr. President.
Thank you, sir. Mr. Hamilton?
No, Mr. President.
All right. I'm reminded by our tribunal secretary just before we begin to note that this hearing today is being broadcasted, as you will have understood from the previous notes which have been submitted and my welcome just a few moments ago, to the extent that there is any confidential information which is going to be aired in the course of the hearing today, which parties feel appropriate to go off record on. Kindly let us know, and we can make the appropriate arrangements. All right, is that clear, gentlemen?
Yes, it is. Thank you.
Yes? Natalie?
That's clear.
Very good.
Thank you.
All right. Thank you very much. Then, that being the case, please let us invite Mr. Hamilton to begin his oral submissions. Thank you.
We will be pleading initially in Spanish, Mr. President. A copy of the presentation that we'll be utilizing for the oral argument. Yes. Los dos, pero en inglés para.
Both, but for you in English.
Claro que sí.
Yes, of course. We are in Washington, D.C., concerning an international arbitration. The tribunal are not using the microphone. Is it okay? Testing, testing, testing into English interpretation. Testing, 1, 2, 3. Testing, testing, 1, 2, 3. You cannot hear me? Testing, testing, 1, 2, 3. Testing, testing. Testing, 1, 2, 3. English should be probably in channel 1. Testing, testing, 1, 2, 3. Testing, testing. Testing the English channel. Testing, testing. Testing the English channel. Testing, 1, 2, 3. Testing, testing. Testing into English interpretation. Testing, testing into English interpretation. Can you hear, Mr. President? Good. Thank you very much. Thank you. Please don't forget to switch your microphone on when you speak, otherwise I can't hear you.
Switch the microphone on when we speak, otherwise the interpreter cannot hear. Thank you.
Ready? Muy bien.
Very well. Dear Mr. President and members of the tribunal, Secretary of the tribunal, good morning. And also good morning to the representatives of Renco and the representatives of the U.S. government. I thank Ambassador Miguel Castilla for his presence and his opening remarks. I am Jonathan Hamilton. I'm a partner at White & Case LLP. It's an honor to present the arguments of the Republic of Peru to you and the audience who are listening live over video. This hearing is part of the first dispute under the United States-Peru Trade Promotion Agreement, an agreement known also as a free trade agreement, or FTA, that came into effect in 2009. On the one hand, the Republic of Peru. On the other hand, the company Renco. And in the Andes, an area called La Roya. In its notification of intention for arbitration, Renco referred to the purpose of the agreement, the FTA, pointing out that the FTA was designed to eliminate obstacles to trade and promote private investment. The agreement has other purposes and goals that are not mentioned by Renco. As Peru pointed out from the beginning of this affair, the treaty, the agreement, also provides, among other things, for the promotion of integral economic development to reduce poverty, to create new opportunities for employment, and improve labor conditions and standards of living, promote transparency, as shown in the management of this process, to implement the agreement coherently with the protection of the environment, to promote sustainable development, strengthen environmental cooperation, preserve the capacity to safeguard public well-being. These goals also are in keeping with the Peruvian government's development program and the investment program developed and maintained by Peru for over 2 decades. Peru developed its economy for the benefit of all and has maintained reasonable expectations that any investor will comply with the relevant agreements or contracts and the applicable standards to protect everyone, to protect citizens and the environment. And Peru respected the agreement. As backdrop, and considering that this is the first hearing before this tribunal unrelated to procedural matters, I'd like to share some observations concerning La Oroya. The breach of the FTA by Renco before the tribunal today doesn't require much background information, but in a few words, La Oroya is a town in the Peruvian Andes where Renco acquired a metallurgical plant that was operated through its Peruvian subsidiary, Duram. La Oroya, because of its nature, is a source of metallurgical raw material. It's a community with schools, homes, churches, with children, parents, mothers and fathers, with companies and with workers. It is an economic site. It is a human settlement. And it is a settlement where there is a high chimney for spewing lead for a metallurgical plant, as we can see in this photograph that is part of the dossier on this case. For many years prior to the entry into effect of the Trade Promotion Agreement in 2009, the basis for the claims by Renco to this tribunal were already underway. In 1997, Renco acquired the complex through Doe Run Peru through a share acquisition agreement. Although they were going to conduct although Peru had promised to comply with the PAMA, it was not done. And thus, children from La Oroya presented claims in United States tribunals in 2007, 2008, with serious claims as to the damage caused to their health. In this context, the Ministry of Mines and Energy and the Peruvian state have sought to cooperate in the applicable framework and within the contractual framework. One must recognize that this cooperation led to concerns by some of the citizens themselves as well as international observers. This, however, is not the time to address all of the background information. In fact, we will be focusing on the basic facts that are relevant today for the tribunal, having to do with the particular exception brought by the Peruvian state. Consistent with the agreement, Peru has been following the situation in La Oroya, as well as many legal proceedings brought by Renco or its subsidiaries, including the local disputes in Peruvian courts. And before this tribunal, Peru has always balanced the protection of investment with its obligations under the agreement, always based on the framework and in keeping with the FTA. Renco, on the other hand, has not complied with the agreement in starting this arbitration, and this brings us to the particular topic to be addressed by this tribunal and the few relevant background information aspects. First, the waiver requirement. The trade promotion agreement provides that disputes concerning investment can be submitted to international arbitration in compliance with applicable requirements. It should be recognized that Peru has signed many agreements for the promotion of investments and has been a diligent participant in the field of international arbitration. Moreover, thanks to its good behavior, Peru has achieved an impressive success record in the world of investment arbitration. The United States is another state that has a successful record. For Peru, these successes include a number of cases brought here before the World Bank in Washington, D.C., that have been heard here. We are far from that time, half a century ago, of the dispute of La Rey Periñas in Peru, when there was no international arbitration system in place. The trade agreement has an absolute condition and limitation for the consent of the Peruvian state to this arbitration. Whoever wants to present a claim for arbitration must provide with a waiver, a written waiver with the notice of arbitration, a waiver as to any right to continue or begin processes with any measure that could be alleged to be a breach of the agreement. Now let's look at the breaches to the agreement. Renco complied with this condition of the agreement. Neither Renco nor Doe Run Peru have presented the absolute waivers that are required, and they have insisted on beginning and continuing two legal proceedings in Peru. Renco presents excuses. Renco's arguments are a lot of smoke. The consequences. As Renco admits, and cannot be denied, Renco does not say that the issue of the indefinite waiver leads to consent. In reality, the consequence of the agreement breaches by Renco is quite clear. Consent by Peru has been vitiated. The tribunal does not have jurisdiction, and I state this respectfully. As explained, by the United States in its presentation to the tribunal yesterday, and with a simple translation of English, if all the formal and material requirements are not complied with, the waiver will be considered ineffective and cannot result in consent of the respondent under the agreement, and the tribunal will lack jurisdiction. Mr. President and members of the tribunal, Peru will be addressing 3 issues in greater detail for the benefit of the tribunal. First, the simple language of the agreement and the simple fact of Renco's violations. Second, we will systematically address the enforcement of the agreement and the legal precedents that rebut the defenses presented by Renco. Lastly, we will conclude with comments on the context and consequences of treaty violations by Renco. We will now switch to English for the benefit of the members of the tribunal.
Slide. First, we're going to discuss the plain and direct objection of the Republic of Peru before the tribunal. The plain language of the waiver requirement in the treaty, the plain facts that demonstrate the violations by Renco, and the plain consequences that affect the future of this proceeding. The treaty, as we've discussed, promotes and protects investment. And of course, it has broader objectives than merely the interest of one company. Rather, it relates to the development of 2 countries and their people, as well as investors. The treaty, in that context, provides an investment chapter that contains the consent of each state, Peru and the United States, to arbitration. It's Chapter 10 of the treaty. But that consent to arbitration is not unlimited. As set forth in Article 10.18(2)(b), the consent of each state and of the Republic of Peru is conditioned and limited by a waiver requirement. And I'm currently on page 10 of the presentation for your reference. And you have here the text of Article 10.18(2)(b), conditions and limitations on consent. And I'm going to read it for the avoidance of doubt. No claim may be submitted to arbitration unless the notice of arbitration is accompanied, 1, for claims submitted to arbitration under Article 10.16(1)(a) by the claimant's written waiver, and 2, for claims submitted to arbitration under Article 10.16(1)(b) by the claimant's and the enterprise's written waivers of any right to initiate or continue before any administrative tribunal or court under the law of any party or other dispute settlement procedures, any proceeding with respect to any measure alleged to constitute a breach referred to in Article 10.16, which is the article setting forth various investment protections that form the basis for the allegations of Renco before this tribunal. Now, let's be clear. The waiver requirement only has a single exception, and it is set forth in Article 10.18.3, which refers to an exception related to interim injunctive relief. In Spanish, una medida cautelar, for the sole purpose of preserving the claimant's or the enterprise's rights and interest during the pendency of this arbitration. To be clear, this exception is inapplicable, and we will hear from Peruvian counsel specifically how the proceedings in question include the option, legally there's an option of seeking injunctive relief, medida cautelar, and that is not what Renco or its subsidiaries chose to pursue when they commenced these proceedings and pursued them. Now, it's important to note that the waiver requirement has a formal component and a material component. One way that we've expressed this in our pleadings is that there is a requirement in word and a requirement in deed. The United States submitted to the tribunal yesterday comments in its capacity as non-disputing party and counterparty to Peru in the treaty that articulates this point very clearly. And I refer you to paragraph 7 of the position of the United States of America, which states, compliance with Article 10.18 entails both formal and material requirements. A claimant must not only provide a written waiver, a formal requirement, but must also act consistently with that waiver by abstaining from initiating or continuing proceedings with respect to the measures alleged to constitute a Chapter 10 breach in another forum. Material requirement. If all formal and material requirements are not met, the waiver shall be deemed ineffective and will not engage the respondent's consent to arbitration under the treaty, and the tribunal will lack jurisdiction. And to be clear, Peru and the United States, the parties to the treaty, agree with respect to this interpretation. Let's compare the requirements of the treaty with the reality of the conduct by Renco. The requirements, a formal requirement of absolute written waivers. The reality, qualified waivers, and no waiver at all with respect to the enterprise, as contemplated by the treaty, do run Peru. Material requirement, no other proceedings should be ongoing as commenced by Renco and its enterprise. Reality, ongoing local proceedings continued and initiated since the filing of the treaty proceeding. Let's take a look first at the lack of compliance with the formal requirement. And I direct your attention to the notice of arbitration that Renco and Do Run Peru submitted in April of 2011. In these form of waiver set forth in paragraph 78 of the Renco Notice of Arbitration, it refers to a waiver by Renco and its affiliate of the right to initiate or continue before any administrative tribunal or court under the law of any party or other dispute settlement procedures, any proceeding. But it adds, to the extent that the tribunal may decline to hear any claims asserted herein, on jurisdictional or admissibility grounds, claimants reserve the right to bring such claims in another forum for resolution on the merits. Now, the whole point of this provision is that a claimant investor needs to make a choice. You can't have your cake and eat it too. You can't take many bites at the same apple at the same time. That's why this treaty includes this provision. Now, what happened after this initial written waiver? In August of 2011, as indicated on page 15, Renco amended its notice of arbitration, and it correspondingly amended its waiver. It specifically removed Doe Run Peru, its enterprise, but maintained also its reservation. It also separately sent a letter expressly withdrawing the prior waiver by Doe Run Peru. Now, that waiver language is in the amended notice of arbitration at paragraph 67. As we will see later, it then, with this waiver in place and Doe Run Peru removed, commenced actions through Doe Run Peru at the local level and continued ongoing actions. Now, just to be clear, Peru raised concerns as to waiver in a timely fashion. Peru noted the issue of waiver in correspondence in 2011. It noted this in its preliminary response to Renco. The case before you, members of the tribunal, was suspended for an extended period of time due to collaborative efforts to find a solution with respect to the future of La Arroya. So there was no tribunal and nothing was proceeding. The tribunal was then constituted, a schedule was put into place, and Peru then raised its objection accordingly. Now, it's noteworthy that when Renco described its own waiver in its memorial of February 2014, it summarized it without including the reservation. The reservation is there, but Renco didn't bother to mention the reservation in its memorial. And as a matter of fact, as we will see later, Renco has selectively disclosed its waivers, or lack of waivers, reservations, the existence of the treaty proceeding in different places at different times to suit its own needs with no regard for the requirements of the treaty. Renco's form of waiver violates the treaty by not waiving all rights. The waiver requirement is absolute. An investor cannot rewrite its waiver to meet its own short-term needs, because the purpose of the waiver provision in the treaty is to protect the procedure of investment dispute resolution and protect it from competing and conflicting proceedings. Renco's waiver is simply insufficient. Now, it's important to note that not only is Renco's waiver insufficient, but again, as I mentioned, there's no waiver at all with respect to Doe Run Peru. Now, Doe Run Peru initially was a party to the arbitration that Renco attempted to commence in April of 2011. The case was styled as Renco and Doe Run Peru against Peru and Activos Mineros, a state enterprise of the Republic of Peru. That did not comply with the treaty. That was at odds with the treaty. Renco subsequently amended its notice of arbitration and removed Doe Run Peru. But to be clear, it did not correspondingly remove all of its treaty claims or any of its treaty claims related to Doe Run Peru. That is exactly why the treaty has the concept of the enterprise of the claimant. So if you just take a look at the original notice of arbitration and amended notice of arbitration and the claims related to alleged breaches under the treaty, the claims are articulated in exactly the same way, as you can see in a comparison of the table of contents. In fact, the only thing Renco did is added an extra piece related to alleged violation related to Doe Run, Peru, in connection with a force majeure clause. Renco did not otherwise change its claims. Its claims stayed the same, and you can see it paragraph by paragraph. And on page 22, we've set forth a table comparing the notice of arbitration and the amended notice of arbitration. And as you see, they're exactly the same. Exactly the same, with the exact same references to Doe Run, Peru. And in its memorial, Renco continues to make treaty claims on behalf of Doe Run, Peru, the enterprise. And I refer you to claims related to fair and equitable treatment, national treatment, expropriation, and reference after reference after reference to Doe Run, Peru in Renco's memorial and treaty claims. In fact, if you literally look at every word of their memorial, and every word, if you compare the notice of arbitration and the amended notice, there are no changes. Yet, they withdrew the waiver and turned around and used DRP to start a local proceeding. And with that, we move from the formal violation, the lack of sufficient waivers for Renco and Doe Run, Peru, and let's look at the material violations by Renco. The Renco group chose to initiate local proceedings. It has chosen to continue local proceedings. Now, Renco has tried to allege recently and creatively that there's a special exception to the treaty that they've created for themselves, which is the defensive exception to the treaty. Well, the devil made me do this. I didn't have any other choice but to violate the treaty. That's effectively what Renco has said. But look at the proceedings in question. And you don't have to look far. The tribunal need not enter into a complicated factual analysis, as Renco appears to want, because the facts are not complicated. In violation of the treaty, Renco, through DRP, filed and continued a first proceeding, an amparo proceeding, a claim for constitutional amparo action against the Ministry of Energy and Mines. It later filed an administrative proceeding stating, we lodge a challenge to administrative resolution by the appropriate process for a special proceeding against Indecopi. That was a violation of the treaty. Very clever effort. We'll remove DRP, keep all our claims the same, and go out and violate the waiver requirement. That's exactly what they've done. They don't get to rewrite the treaty for their own benefit. Now let's be clear that the local proceedings, these two local proceedings, and we'll look at the timeline of them in a few minutes, they concern measures alleged to breach the treaty, as set forth in the notice of arbitration, amended notice of arbitration, and memorial submitted by Renco. To illustrate, in the treaty proceeding, Renco alleges that Indecopi, an organ of the Peruvian state, that the recognition by Indecopi of a bankruptcy credit by the Ministry of Energy and Mines constitutes a breach of fair and equitable treatment and expropriation. In the first local proceeding, Renco DRP alleged that Indocopi's recognition of that credit would constitute a breach of DRP's rights. In the second local proceeding, DRP alleged that Indocopi's recognition of that credit was illegal. The local proceedings overlap precisely with a core piece of the treaty claim presented by Renco. Now, as I stated, these local proceedings do not fall into the sole treaty exception, which is in connection with interim injunctive relief. Next slide. If you look at the complaints for these two proceedings.
Excuse me, Mr. Hamilton, just to interrupt you on that point, if I could, please. Just for clarity's sake, because we're eliding the two words from time to time, Renco does X and DRP does X. These local proceedings were all commenced and maintained by DRP, not Renco, the Renco Group, Inc.
Yes, let's look actually at the next slide.
Thank you, sir.
This is page 27 of the presentation. Now, this is a timeline that is directly from Annex A to Peru's memorial on waiver submitted in July of this year. And you can see here the timeline between the local proceedings and the treaty arbitration and also the relevant parties. So the first proceeding was initiated by Do Run Peru, controlled by Renco, in November of 2010. In December of 2010, Renco and Do Run Peru filed their notice of intent with respect to their treaty claims. During the first part of 2011, there were ongoing proceedings, including a loss, an appeal, an affirmation, a second appeal in that first proceeding, all by Do Run Peru, controlled by Renco. During that same period of time, Renco and Do Run Peru filed the notice of arbitration with waivers that were insufficient, and then in August of 2011, filed the amended notice of arbitration with insufficient waivers and a withdrawal of the waiver vis-a-vis Do Run Peru. Now, one other observation regarding this time period. I don't believe that Do Run Peru advised the Peruvian court at that time that separately Do Run Peru was commencing this treaty arbitration. It is noteworthy, however, that promptly after filing the notice of intent in December of 2010, Renco ran directly to the Court of the United States in an effort to remove claims brought by children of La Arroya from state court to federal court. Renco did that by bringing to the attention of the United States federal court the existence of a treaty dispute. This was done based on the notice of intent of December of 2010. So Renco and Do Run Peru at that time filed a notice of intent, ran to the U.S. court, told the court immediately about the proceeding to use it for a protective or prophylactic effect in the U.S. litigation, simultaneously, in violation of the treaty, continued with the local proceeding through Do Run Peru without advising that court, or obviously without stopping the proceeding. Thereafter, Do Run Peru, controlled by Renco, initiated a second local proceeding in January of 2012. Do Run Peru initiated the proceeding, and several months thereafter, the creditors committee of Do Run Peru voted to shift from a restructuring scenario to a liquidation scenario. Renco, through its holding company, Do Run Cayman, together with the Ministry of Energy and Mines and other creditors, voted in a common way to do so. Immediately at this time, Do Run Cayman of Renco intervened in that proceeding and has continued to play an active role in that proceeding, as indicated in the timeline before you, including in March of this year, requesting a ruling in the pending appeal. Now, just to be clear, to my knowledge, there's been no headway for Do Run Peru or Do Run Cayman in these local proceedings. We're not afraid of the local proceedings in that sense, but it is a procedural violation and a jurisdictional violation in the context of the treaty waiver requirement.
Mr. Hamilton, I wonder
Yes, sir.
if I could ask you a question at this point. I'm looking at the table on page 27, as well as your page 24, where you refer to, on page 24, the amparo action we are filing. Would I be correct in finding that the amparo action is actually the February 3, 2011 proceeding mentioned on page 27, DRP files appeal?
That's correct. Do Run Peru
Files an amparo.
filed the amparo. That's the first proceeding.
Okay.
And then the second proceeding.
Moving to the second proceeding, the complaint to the Specialist Judge in Administrative Complaints in Lima. I'm reading from page 24. Would I be correct that in the table on page 27, that is the October 29, 2012 proceeding, DRC files appeal?
That is a reference to the, if you look at page 24, we have sources up top in fine print. And that is a reference, as you can see here, DRP's amparo complaint, and then DRP request for annulment of administrative decision, January 16, 2002. And then the subsequent intervention by Do Run Cayman was in the context of that same second proceeding, the administrative proceeding.
But my answer is the lodging of the challenge, which is referred to on page 24, is that the same as the appeal filed by DRC in October 2012?
That challenge is a reference to the DRP request for annulment of administrative decision, which is 16 January 2012, which is the first step indicated here in the second proceeding. And that's Do Run Peru, controlled by the Renco group.
Yep.
And you can see that reference again in the citations on page 24.
Okay, no, I follow. Thank you.
Thank you.
Mr. Hamilton, just to pick up on that, to clarify one point. My understanding was that the amparo was originally filed on 22nd of November 2010. And what Mr. Fortier had just referred to as the DRP files appeal was the appeal of the amparo, appeal against the court ruling against DRP.
That's correct. As indicated in the timeline, the initial filing in the first local proceeding, the amparo proceeding, was filed by DRP on 22nd November of 2010. And again, if you look at our slide 24 and the citation there, it's a reference to that filing on November 22nd, 2010, which is Exhibit R19. And the subsequent filing of the appeal in February of 2011 was the next step in that local proceeding. Now, yes.
I'm grateful for that clarification.
Thank you very much.
Thank you. And if I may continue with the chairman's consent, in your own words, could you please describe the purpose of an amparo proceeding? An amparo action?
An amparo action in Peru is not identical to amparo actions that some may have been familiar with from other cases. For instance, in Mexico, it's been an issue in various Mexico cases. They're a little different from that. That's been addressed in other Peru cases, such as in the case of Aguatilla v. Peru. and which was a success by Peru in that proceeding. But it's a claim for constitutional relief. It's a claim for constitutional relief, but that constitutional relief, that option and scenario includes, by law, an option of seeking medida cautelar, injunctive relief, and that is not what they pursued. And to assist the tribunal, because we understand, as your questions indicate, that this is a question of significant interest to the tribunal, we are going to hear shortly from Peruvian counsel, Doctora Maria del Carmen Tovar of Estudio Chacopar, and she's going to discuss the specifics of these two kinds of proceedings under Peruvian law. In conclusion, with the first segment of our argument, the plain language of the treaty explains the waiver requirement. It's plain. The plain facts of the existence, filing, initiation, and continuation of these local proceedings demonstrate the violation of the treaty requirement, both in word and in deed. And finally, the plain language of the treaty, as agreed by Peru and the United States, demonstrates the simple consequence. Renco has not disputed that the issue of waiver ultimately goes to the question of consent. We all agree. The consequences are serious, and they indeed are severe, as the treaty contemplated. I'm going to invite my partner, Andrea Miniker, now to discuss in detail the precedents that Peru has relied upon and that Renco has used as we rebut the key arguments raised by Renco in connection with its violations of the treaty. We'll take just a moment to reposition ourselves. Thank you.
Good morning, Mr. President, members of the tribunal. As Mr. Hamilton just noted, I will now discuss each of the three ways in which Renco has violated the waiver provision and demonstrate that none of Renco's defenses to those violations has any merit. So first, and how do I use this? Oh, it's not working. Okay, that thing doesn't work.
Now it's working. Now it's working.
Which thing do I press?
Right, so.
Okay, all right. Yeah, exactly. I haven't.
That's why we're a team.
I don't usually operate that. All right. So the three violations that I'll be describing is first, the violation of the written waiver by Renco by including the reservation that Mr. Hamilton referenced, the violation of the written requirement by DRP not having having withdrawn its waiver and not having provided then a subsequent waiver, and the violation related to the ongoing proceedings. So first, with respect to the written violation, you've seen before, of course, the treaty's requirement for the waiver and the fact that it contains a single permissible reservation for local proceedings seeking interim injunctive relief that are solely is aimed to preserve the claimant's or the enterprise's rights or interests during the pendency of the arbitration itself. And that's the sole permissible exception to the waiver requirement that is allowed by the treaty. And then again, you've seen Renco's waiver that contains the reservation, which is to the extent that the tribunal declines to hear the claim on either jurisdictional or admissibility grounds, that claimant Renco reserves its right to bring such claims in another forum for a resolution on the merits. Now, Renco essentially has made three arguments in defense of Peru's objection that the inclusion of this reservation violates the treaty's waiver requirements and deprives this tribunal of jurisdiction to hear its claim. The first argument that they make is that their reservation is simply superfluous. It doesn't add anything, it's meaningless, they have this right anyway. And that's incorrect. First, the fact that they made the reservation and indeed have maintained the reservation despite Peru's objection is a strong indication that the language is not meaningless or superfluous. And this, in fact, is what the Waste Management Tribunal found in its award when it dismissed the claim. In that case, Waste Management also had included a reservation and similarly made an argument that it was merely superfluous, that it was not at odds with the treaty's requirement. And the tribunal noted, and I quote, "If the claimant, upon formulating its waiver, had clearly adopted the interpretation it now maintains, it would not have conditioned its waiver with the terms as it did, because under said interpretation, it would have been able to take parallel action in domestic courts or tribunals without expressly invoking NAFTA provisions and thereby without affecting these arbitral proceedings." Similarly, Renco has said that in its rejoinder that its waiver should be read as consistent with the treaty's requirements. But that purported intention cannot control. It's the words of the waiver itself that need to control. And if you look at the Detroit Bridge NAFTA decision, award on jurisdiction rather, in one of its waivers, the claimant there also prefaced its waiver by stating that it was consistent with the NAFTA's waiver requirements, that the only exception being taken was for proceedings for injunctive, declaratory, or other extraordinary relief not involving the payment of damages. Then it added, for the avoidance of doubt, that this waiver does not and shall not be construed to extend to certain proceedings. And the tribunal rejected that, found that the waiver itself, that carve-out for those proceedings, did indeed violate the waiver, and it could not be salvaged by the purported intent of the claimant to make its waiver consistent with the NAFTA waiver requirement. And that also applies equally here. Now, Renco is, of course, entitled to adopt the position that it has taken, that any future claim would not be barred by its waiver if this tribunal were to dismiss its claim on jurisdictional or admissibility grounds. And it is free to argue that before any future forum to which it might submit a claim. But that question as to whether its waiver would bar that future claim from going forward must be resolved by that future court or tribunal that is seized with that claim. That's not an issue that should be negotiated with Peru now, and it's certainly not an issue for this tribunal to decide. And that is why we have relied upon the order of termination in the consolidated softwood lumber cases. And you can see here that in that case, one of the claimants sought to withdraw its claim from arbitration right before the jurisdictional hearing. It was displeased with how that hearing was, how the proceeding was progressing, and it actually threatened to refile another NAFTA claim. And the United States, the respondent in that action, opposed the claimant's withdrawal and said that it had an interest in having an award dismissing the claim. It did not consent to having the claim withdrawn unless the withdrawal and the termination was made with prejudice. So it would not be permitted to refile a claim. And as you can see there, that tribunal permitted the withdrawal and said it did not have the competence to determine whether the claimant would be foreclosed from seeking relief before another court or tribunal, whether the dismissal was with or without prejudice. That necessarily fell within the competence of any future forum. And that is why we have cited that case, which certainly supports Peru's position. Renco has argued in its rejoinder that the case supports its position because Renco states that Peru is asking this tribunal to determine now that a future claim by Renco before another court or tribunal would be barred if this tribunal dismisses its claims on jurisdictional or admissibility grounds. But that's not correct. Peru's not asking this tribunal to do that. Again, we're stating that it's for any future tribunal to make that determination. But what Renco wants to do is it wants to predetermine that issue by stating in its waiver that any future claim would not be barred by the waiver. And that's precisely what the Tembec Tribunal in the Consolidated Softwood Lumber order said could not be done. Now, Renco cites several cases to support its argument that a dismissal on jurisdictional or admissibility grounds would have no res judicata effect with respect to any future claim. But again, that's not the question. The issue is whether Peru is entitled to argue before any future tribunal that Renco's waiver precludes it from bringing the claim separate and apart from any argument that this tribunal's decision would have res judicata effect. And indeed, Renco recognizes that these are different arguments. With respect to the second waste management case, it specifically noted that Mexico made multiple arguments before that tribunal, one of which was that the claim was barred by the waiver, another was that it was barred by res judicata. And those are indeed separate arguments. And Renco wants to foreclose Peru from making a waiver defense or putting it forward, although it says that it does agree with the Tembec Tribunal's or the Consolidated Softwood Lumber Tribunal's conclusion that this question really ought to be and must be reserved for a future tribunal. Now, Renco's reservation not only fails to comport with the treaty's language, which is absolute and permits only a single exception, but it also is contrary to the object and purpose of the waiver requirement. And Renco makes several appeals to fairness, and in fact relies on the waste management case in particular to say, look, the waiver did not bar a subsequent claim before a NAFTA tribunal, nor was that claim barred by res judicata. First of all, again, the waiver is a no U-turn provision that doesn't apply to subsequent NAFTA or, investment treaty arbitrations. It's concerned with local proceedings. But separate and apart for that, it certainly may be the case that depending on what grounds a tribunal might dismiss on jurisdictional or admissibility grounds, a waiver might not preclude a future claim. Or in other cases, depending on the grounds for the dismissal, it arguably could preclude the claim. And it would be Peru's prerogative to choose whether or not to raise a defense based on the waiver, depending on the particular circumstances. And so it is certainly, while the only example that Renco has put forward to this tribunal is a waste management case, the tribunal ought to keep in mind that that is a singular example. That is a case where the waiver itself was found ineffective. So before a future tribunal, Mexico was not entitled to rely on that ineffective waiver for claiming that the second case could not go forward. But one can imagine all sorts of grounds on which a tribunal could dismiss on jurisdictional or admissibility grounds, and a waiver could preclude a subsequent claim from going forward, and certainly that it would be in conformance with the object and purpose of the waiver requirement that it might be used in that manner. And I would give the tribunal just a few examples. There are a number of cases, for example, where claims have been dismissed on jurisdictional or admissibility grounds for reasons of illegality. In the Metaltech case against Uzbekistan, the claim was dismissed, the jurisdictional objection was joined to the merits, and the claim was dismissed when it was found that the claimant had bribed a government official in order to secure its investment. The World Duty Free case against Kenya, again, the claim was dismissed on inadmissibility grounds for reasons of a bribe. Plama versus Bulgaria, fraudulent misrepresentations were made to procure the investment. The claim was dismissed. In each of those instances, if a claim is dismissed on that ground and the claimant were to restart a case in local proceedings, the state, very likely, one would assume, would raise similar defenses to the defenses that were raised in the investment treaty cases, because it's quite likely that local law would also preclude a claim from moving forward on a similar basis. And why ought not the state be entitled to present its waiver to that tribunal and say, look, why should we relitigate this issue? We have a waiver. And there again, it's a dismissal on jurisdictional and admissibility grounds, and there's nothing inherently unfair about that. Another example, there are tribunals that have dismissed on jurisdictional grounds, but then have said, well, we are actually so far into our deliberations on the merits, we're going to let you know that your claim would have failed on the merits had we decided that. That happened very clearly in the Lowen versus United States case, where the jurisdictional objection on which the United States ultimately prevailed did not come to light until after the merits hearing, because there had been a bankruptcy and reorganization that ultimately led to a change in the nationality of the claimant that deprived the tribunal of jurisdiction. Right at the front of its award, it states that, however, because the tribunal was so far into its deliberations, we are going to, for the benefit of the parties, let you know that the claim would have failed on the merits and explain why. But there in the dispositif, it's very clear that the dismissal was on jurisdictional grounds. According to Renco, if that were its case, it could then bring a local proceeding challenging the same measures because it was a dismissal on jurisdictional grounds, and the state would have to defend all over again. Methanex was similar in that regard because it dismissed ultimately on jurisdiction, but also held that the claim failed on the merits. Yet another example, if one looks at Occidental versus Ecuador, there the claim dealt with the Ecuador's refusal to allow reimbursements for certain VAT payments. And the claimant states, and this is on the slide number 35, that a claim for expropriation should normally be considered in the context of the merits of a case. However, in this particular case, the tribunal felt that it was, quote, so evident that there is no expropriation that the tribunal will deal with this claim as a question of admissibility. It then went on to look at the expropriation claim and held that respondent did not adopt measures that could be considered as amounting to a direct or indirect expropriation, and in fact, there has been no deprivation of the use or reasonably expected economic benefit of the investment, let alone measures affecting a significant part of the investment. And the tribunal then accordingly held that the claim concerning expropriation was inadmissible. In that case, the tribunal did find a national treatment violation and a fair and equitable treatment violation. But imagine if the tribunal had dismissed the fair and equitable treatment claim and the national treatment claim on the merits. Then again, according to Renco, it could not relitigate those claims because those were merits dismissals. But the even more unmeritorious expropriation claim that didn't even make it to the merits because it was so lacking in merit or substance, according to the tribunal, that it was dismissed on admissibility grounds, it could relitigate because its waiver would carve this out. And finally, I would point to examples from this case in particular. As the tribunal is well aware, Peru has made several objections in accordance with Article 1024, or rather several arguments in support of its 1024 objection. And in Renco's latest supplemental opposition to Peru's objections, it objects on the grounds that several of these are really jurisdictional in nature. And so it says, for instance, that the objection that that Peru could not have breached any obligations under the stock transfer agreement because it's not a party to that agreement relates to the tribunal's jurisdiction. That Peru's objection based on its status as a non-signatory to the stock transfer agreement, even though it's a signatory to the guarantee agreement, relates to the question of the tribunal's jurisdiction. That Peru's objection that there's no breach of the guarantee agreement because the guarantee agreement is void under Peruvian law because it had been assigned concerns the tribunal's jurisdiction. And that Renco's alleged failure to submit some factual issues to a technical expert goes to the competency of the tribunal. So again, if this tribunal, according to Peru, if this tribunal were to agree that these were jurisdictional objections, with which Peru, of course, disagrees, but if it were to agree with Renco, and it were ultimately to dismiss the claim for lack of jurisdiction on any of these grounds, then, according to Renco, it should be permitted to then go to court and argue for the same exact breaches related to the same exact measures that Peru should be held liable for breaches of the stock transfer agreement and the guarantee agreement, and Peru would have to argue, make these same arguments about being non-signatories to this agreement and be unable to use its waiver to bar those claims, even though it's clearly comports with the object and purpose of the waiver requirement that Peru should only have to defend on those grounds once. So Renco's argument that it makes in its rejoinder that if a claim is dismissed on jurisdictional or admissibility grounds, there is no risk of inconsistent results is clearly incorrect, as these examples show. One can think of numerous examples where there could be inconsistent results if the same jurisdictional or admissibility objection is heard by more than one tribunal. And keep in mind, of course, that the waiver has to be filed at the time that the notice of arbitration is submitted. At that time, the claimant has no inkling of what objections the respondent state might raise. And we still don't know the full scope of jurisdictional or admissibility objections that Peru might raise. And yet Renco is arguing that regardless of which objections are raised, if they are jurisdictional and admissibility objections, that those all should be carved out of the waiver. Okay, now the second argument that Renco makes in response to Peru's objection that the written waiver is non-conforming and thus deprives the tribunal of jurisdiction is that no tribunal has dismissed a claim on this ground when there weren't ongoing proceedings that were in violation of the waiver. And this objection is also without merit. First, it finds no support in the treaty whatsoever. The treaty requires a written waiver that conforms with the treaty's terms, in addition to compliance in material respects. And this was confirmed by, again, the waste management, this is the second waste management tribunal. And you can see here, it says that the first tribunal stressed that the lodging of a waiver in conformity with Article 1121 is a condition precedent to the submission of a claim to arbitration. As an aspect of its power to determine its jurisdiction, the first tribunal had to determine both, two things, that the waiver conformed to NAFTA requirements and that it was a genuine waiver expressing the true intent of the claimant at the time it was lodged. So there, the tribunal's clearly recognizing that it's a dual requirement and both need to be satisfied. And indeed, the United States, in its written submission that Mr. Hamilton referenced earlier today, expressly agreed with this approach, that of course it is a dual requirement, and that if the written waiver does not conform with the treaty's requirements, then that vitiates the state's consent to arbitrate. The language of the treaty is clear, that it requires a waiver and it should not lead to any deviation in that waiver. Now, I apologize, let me just look for the, in fact, Renco's argument, the other point that I wanted to make on this is Renco's argument that only ongoing proceedings could violate or vitiate the state's consent and not simply the non-conforming written waiver, as we've shown, is not consistent with the language of the treaty, is also inconsistent with the views of both parties to the treaty, the United States and Peru, and also the jurisprudence. And significantly, it would deprive Peru of one of the key benefits of the waiver, because in Renco's view then, claimants only would be barred from concurrent violations, but not future violations. a claimant could carve out of its waiver, really as Renco has done, any sort of future proceeding that it might intend to bring. And under Renco's interpretation then, only if it were proceeding simultaneously with the arbitration concurrently would the tribunal lack jurisdiction, but it would be able to, after the arbitration finalized, if it was unpleased with the result, then go and pursue those second proceedings. And that clearly is at odds with the no U-turn provision in the treaty and would deprive the state of one of the key objectives and benefits of the waiver and no U-turn provision, which work hand in hand. And Renco, notably, in its rejoinder, did not acknowledge or respond to this observation at all, which clearly undermines its argument that its actions are consistent with the object and purpose of the treaty. And the last point that I want to make on the written waiver violation is Renco's defense that this can be easily remedied. It said, well, finally, if the tribunal doesn't agree with us and finds that this is a problem, we can just submit another waiver without that last sentence. And that, too, is incorrect. Renco relies on two cases, Ethel and Thunderbird. In those cases, fully compliant written waivers were submitted with the statement of claim and not with the notice of arbitration. And in both of those cases, the tribunals declined to dismiss on jurisdictional grounds because of the tardiness of those waivers having been submitted. And those cases are clearly distinguishable. First, the written waivers were fully compliant. There was never a non-complying waiver. Second, there was a debate under the NAFTA's language, which is different from the language in this treaty, as to at what point in time the waiver needed to be submitted. It has been consistently the United States' and the other NAFTA parties' position that the language submission of a claim to arbitration means with the notice of arbitration, but those two tribunals found that it was okay for it to be done with the statement of claim. In our treaty, however, that uncertainty is taken out of the treaty because our treaty states that it needs to be submitted with the notice of arbitration itself. And if you take a look at the Detroit Bridge, that is a NAFTA tribunal that did get this issue right, it does say that the waiver needs to be submitted as of the date of the notice of arbitration. It can't be remedied afterwards. The United States, again, in its second submission filed yesterday, clearly agrees. The date of the submission of an effective waiver, it states, is the date on which the arbitration commences. And if you take a look at two cases, I think this really brings this to light. In these two cases, in waste management, as we've heard, there were a violation of the written form of the waiver, and there were also ongoing proceedings that were found to have violated the waiver, and the case was dismissed for lack of jurisdiction. What's notable here is that all of the ongoing proceedings, the local proceedings, had ended before the hearing in that case. But that did not matter because what the tribunal was concerned about is, as of the time of the notice of arbitration, was there a violation of the waiver? And it was found, yes, it was a violation as of the time of the notice of arbitration. So the same way in which you can't submit a conforming waiver now by simply changing the language, here they could not correct that violation by simply discontinuing the local proceedings at a later point in time. The same thing in the Commerce Group case. And there, I think it's even more stark because, interestingly, here you had a long period of time, just about a year, after the notice of arbitration and the waiver was filed, when the claim was suspended before the tribunal was even constituted, much like in this case. And the local proceedings at issue were concluded before the tribunal was even constituted in that case. And then the respondent raised an objection that the local proceedings that had taken place before the constitution of the tribunal, but after the submission of the notice of arbitration and waiver, vitiated the state's consent because it rendered the waiver ineffective. And indeed, the tribunal agreed and dismissed that claim for lack of jurisdiction.
With the chairman's permission, if I may, Ms. Manager, on this last facet of your argument, the claimant add a second leg to their argument that it's superfluous and we could simply write it out, in effect, make it disappear. And they say, well, the respondent hasn't suffered any prejudice. How do you answer that statement?
Yeah, we disagree. That the tribunal does not have the authority to simply write it out or to permit Renco to submit a complying waiver in order to recreate its jurisdiction in some manner. And the United States also agrees with this, made it clear in their second submission yesterday, right at the last paragraph of its submission, where it states...
I saw that.
Okay, quite clearly, and I think that the cases that I've just shown you also all agree there, that it's simply not, it's a condition of the state's consent that must be met at the time that the notice is...
Prejudice doesn't enter the picture.
That's correct, because we've been prejudiced by the nonconformity with the prerequisites to consent to arbitration. In the same way that in the Commerce Group, there was, one could say, well, no prejudice. By the time the tribunal was constituted, there were no ongoing proceedings. They had concluded. And yet there, once again, because the waiver was ineffective at the time it was filed, it was rendered ineffective by the non-complying conduct, the case was dismissed. And I would point the tribunal, in addition to those cases, to the cases that I have on the next two slides, the Detroit Bridge case, where there again the claimant submitted multiple waivers. In fact, at the hearing, it submitted a third waiver, trying to correct its other waivers. And the tribunal said it doesn't consider that the submission of such documents could retroactively validate several months of proceedings during which the tribunal wholly lacked jurisdiction but had some kind of potential existence that might have been realized if it had acquired jurisdiction at some subsequent date. And the Railroad Development Corporation case against Guatemala is the same. And it says, because this is a matter pertaining to the consent of the respondent, the tribunal has no jurisdiction without the agreement of the parties to grant the claimant an opportunity to remedy the defective waiver. It's for the respondent and not the tribunal to waive a deficiency under Article 1018 or to allow a defective waiver to be remedied. Sure. Okay, now I'm going to move on to...
Can I just, before you move
Yes,
on,
please.
just ask one point of detail from your written submissions? Paragraph 19 of Peru's memorial, where the point is made as to a failure to comply with the formal requirement. I wasn't quite sure whether there are 2 points or 1 point being made here. Paragraph 19 seems to raise two objections. The first one being that Renco has failed to waive any right to initiate, because the wording is not any right, it's its right. And then paragraph 19 moves on to the qualification that's added. Are those 2 points, or is it 1 point?
I would, if I could just, at the break, take a closer look
Sure,
at it
absolutely.
and elaborate on rebuttal.
Yeah.
Okay. So now I'd like to move on to the second violation, which is the lack of a written waiver by DRP. Here, as Mr. Hamilton noted, the background of this, where DRP initially submitted a waiver, purported to withdraw the waiver, and then with the amended notice did not submit a new waiver. As you're aware, the tribunal, that's okay. Okay. So the treaties allows the submission of a claim to arbitration Either on behalf, the claimant can make a claim on its own behalf, or it can also make a claim on behalf of an enterprise that it owns or controls. If it makes a claim on its own behalf, it must submit a waiver. If it makes a claim on behalf of an enterprise it owns or controls, it must submit a waiver on its own behalf and for the enterprise. Now, Renco basically makes two arguments in response. One is that we cannot recharacterize its claim. It is now saying it is making a claim on its own behalf, and that is the provision it has invoked. It is saying that it is not making a claim on behalf of DRP, and we just have to accept that. And again, we strongly disagree. It would defeat the object and purpose of the treaty if claimants were permitted to circumvent the clear requirements of the treaty and the waiver provision by simply drafting their request in a manner to not have to submit a waiver. The tribunal has to look at the request for arbitration and determine whether the required waiver was submitted in light of the claims that are actually being made, and without accepting at face value claimant's assessment as to whether the claims that it is making are claims on its own behalf or are claims on behalf of the enterprise that require a waiver for that enterprise. Claimants go to great lengths to argue that they are not making claims on behalf of DRP, but they completely ignore the fact that their claims didn't change in substance between their original and their amended notice of arbitration, except for respects that are not relevant to this issue. They never attempt to explain how the claims that are set forth in their original notice of arbitration were claims on behalf of DRP. They acknowledge they were claims on behalf of DRP, and how those same claims have now morphed into claims on behalf of Renco alone. They are making claims for breaches based upon the same measures, and they are seeking compensation for the same harm arising out of those measures in both notices, and yet they're now not providing a waiver for DRP. And I'm not going to spend time on these slides because you saw them with Mr. Hamilton's presentation, but this is simply to show you that the claims are the same in both the original and the amended notice of arbitration, and that when you read both their amended notice of arbitration and then their memorial on liability, it is clear that they are complaining about measures that were directed to DRP and that the harm that they suffered as a result of their interest in DRP. And again, Renco is wrong to say that the tribunal simply needs to accept their characterization of the claims. And I would direct the tribunal's attention in this regard to the Mondev case, where there the tribunal noted the distinction between Articles 1116, which are claims on the claimant's own behalf, and Article 1117, which are claims on behalf of an enterprise. And it stated that a NAFTA tribunal should be careful not to allow any recovery in a claim that should have been brought under Article 1117 to be paid directly to the investor, because the tribunal will recall that if a claim is made on behalf of an enterprise, any award in favor of the claimant is made to the investment and not to the claimant itself. And the tribunal goes on to say there are numerous ways of achieving this, most simply by treating such a claim in truth brought under Article 117, provided that certain conditions are met, including provided that a waiver is being submitted on behalf of the enterprise, and I'll talk about that provision in a little more detail in a moment. So what the tribunal, though, the point that I'm making here is that the Mondev case, that tribunal clearly recognized that you don't need to simply accept the characterization of the claim made by the claimant, that the tribunal has a responsibility to look at those claims and determine if they should have been made on behalf of the enterprise, and if so, to treat them as claims made on behalf of the enterprise. What the tribunal is going on to say there is, essentially, well, we agree that these claims should have been made on behalf of the enterprise. We're not going to dismiss it for lack of jurisdiction in that case because it has no practical consequence, because in that case, the enterprise had provided a waiver, and the claims failed, so there was no award to be paid. And they're saying we could have made the necessary adjustments had that been the case. But again, they're saying that you need to make sure it is brought on behalf of the proper, under the proper article, and make necessary adjustments. Now, Renco, the second thing that Renco argues is that it can make a claim on its own behalf for indirect harm to the enterprise when it owns or controls the enterprise. But again, Peru strongly disagrees with that. Renco's own actions show that they understood the difference between making a claim on their own behalf and making a claim on behalf of an enterprise. They understood the nature of their claims, and they understood that these claims were properly made on behalf of DRP. And in fact, if Renco could make the same claims but simply pick or choose under which article they want to bring those claims, it would render these provisions meaningless. There is a clear distinction between claims on one's own behalf and claims on behalf of an enterprise. It would render the distinction meaningless if you could pick and choose. It would also render the waiver provision ineffective, because when there was a claimant that owned or controlled the enterprise, its own waiver would be rendered practically meaningless, because those same claims could be pursued by the wholly owned or the majority owned enterprise, and you would wind up with the same problem that the waiver provision is intended to foreclose. Now, minority shareholders, of course, cannot waive the enterprise's rights, and that's why Renco's reliance on the Tico case against Guatemala is inopposite. By the same token, a minority shareholder can't instruct or direct the enterprise to initiate proceedings. So the state has no risk of being subjected to claims in different fora for the same measures prosecuted by or under the instruction of the same claimant when you're dealing with a minority shareholder. When you're dealing with a shareholder that owns or controls an enterprise, it's entirely different. That's when you have the risk of being subjected to the same claims, challenging the same measures by both the claimant and the enterprise in different fora. And that is why the treaty requires the claimant to supply a waiver on behalf of the enterprise when it is making those claims for what we would call indirect injury that it has suffered on account of its shareholding in that enterprise. Now, Renco relies on the article, a footnote in an article written by Ms. Thornton, and its reliance on that article is wrong for two reasons. This article is actually proves Peru's points. First, Renco argues that this article shows that it can make a claim on its own behalf for injury that it has suffered as a result of its interest in the enterprise. But if you look right above the highlighted portion, there's a citation to an article by Dan Price, who is one of the drafters of the NAFTA. And he states there, Article 1117, which is the article that permits a claimant to submit a claim to arbitration on behalf of the enterprise, is intended to resolve the Barcelona traction problem by permitting the investor to assert a claim for injury to its investment, even where the investor itself does not suffer loss or damage independent from that of the injury to its investment. The corollary to that is that claims under 1116, which are claims on behalf of the claimant itself, may only be brought wherein an investor suffers loss or damage that is independent from that of injury to its investment. And that is also made clear in the United States' second submission, where it cites to it makes this claim, and then it cites to another submission that it made in another case, in the GAMI versus Mexico case, where it says, consistent with the prevailing rule under customary international law, Article 1116 provides standing for direct injuries, and Article 1117 provides standing for indirect injuries. And it cites to the NAFTA Statement of Administrative Action, which is the document that was created contemporaneously with the passage of the NAFTA and submitted to Congress. And it says that Articles 1116 and 1117 set forth the kinds of claims that may be submitted to arbitration, respectively: allegations of direct injury to an investor and allegations of indirect injury to an investor caused by injury to a firm in the host country that is owned or controlled by an investor. And again, Renco simply wants to ignore the distinction between these two articles, their corollaries in the treaty, and to say that it is entitled to bring what is a claim for indirect injury, a claim that should have been brought on behalf of its investment, and it is entitled to bring that claim on its own behalf, just under the other article.
Can I just ask
Yes.
sorry to interrupt, but given the distinction between direct and indirect injury, where would you place a claim, a hypothetical claim for, by an entity in Renco's position for a diminution in value of its shares?
I place that as an indirect claim because it's the damages to the investment itself, and the indirect consequence of that is that the value of your interest in the investment has, been diminished. And that's different from a direct claim where your rights as a claimant, as an investor, are directly affected. For instance, if your shares are actually seized, you own the shares and they take your shares, that would be a direct injury to the investor. If you were deprived of the ability to vote your shares, to receive dividends, all of those are direct injuries. But when the injury is just a consequence of the diminution in the value of your investment due to the harm that is directed towards the investment, that would be an indirect injury.
Forgive me if I just follow up on that. Just to be clear, though, how you're drawing that distinction, what would be the difference, though? On the one hand, you'd be suggesting that if shares have been expropriated, for example, or taken away, then that would be a direct injury, because that would be an entity in Renco's position suffering harm to its investment, and its investment would be the subsidiary.
Mm-hmm.
But then, on the other hand, why is that different from a diminution in value in shares if an entity in Renco's position is left in its hands with shares for which it can get only a lower value if it wants to sell them?
Because again, I think I was also drawing a distinction between perhaps the taking of all of the shares in the enterprise or the taking of just the claimant's shares in the enterprise. But I think that if the shares that the claimant is holding directly are somehow taken away, there's a measure that says that foreigners can no longer hold shares in this particular enterprise. That clearly is a measure that's directed at the claimant itself and is a direct injury to the claimant, whereas I think the other types of injuries that you're discussing they're derivative in nature, essentially, that the harm is done to the enterprise, and the only reason you're suffering is because you own an interest in that enterprise. You are a shareholder.
But the enterprise and forgive me for asking the question,
That's
but
okay.
the enterprise in that situation, isn't that the investor's investment? And so what's happened is the damage, just to pursue the argument,
Right.
the damage to the enterprise equals damage to the investor's investment. Why isn't that a direct claim by the investor? The investor's complaining about damage done to its investment.
Well, I think that it is, I still believe that it's indirect because, again, it's not something that is directed to you as the foreign investor. It's being directed to the foreign investment. And so you are suffering a consequence of the harm that is being directed to the foreign investment.
Wouldn't you say the same? Well, I'm just struggling at the moment to see the distinction with the all-out expropriation
Right.
example.
The United States, for example, gave an example in one of its submissions where it said, for instance, if there was a preclusion or prohibition on the transfer of funds out of the country, the claimant might have a direct claim if it was unable to receive dividends that it was otherwise entitled to. Whereas it might have an indirect claim if the investment itself suffered because it was unable to carry on its day-to-day operations because it could not make payments for supplies or something. That's an injury to the investment, and then the investor, of course, is harmed by that, but again, its injury is indirect because it's only by virtue of its owning the shares in that investment when the measures are directed towards that investment. And again, we're talking about the situation when you have an investor that owns or controls the enterprise, where this becomes, a real issue, because then the investor is in a situation where it can not only, of course, produce the waiver for that enterprise, but it can direct that enterprise to then take action to challenge those very same measures that are harming it directly. and the harming the enterprise directly and harming the investor indirectly. And so in those instances, that's why I think the distinction has to be given some meaning, and I think that's the meaning that was clearly anticipated by the parties, or intended by the parties, as the statement of administrative action and such, and the subsequent submissions by the parties shows. And I think that the repercussions are important, both in terms of a payment of an award. Like you said, wouldn't it be the same harm? I mean, in some situations, of course, we have the issue with creditors who, yes, you might suffer harm from the same measure, but your damages would be quite different. I mean, the award should be paid in cases where the measure is directed to the investment, to that investment, because the shareholders' interest is, of course, subordinated generally to debtors. So, and if you kind of take away that distinction, then you allow kind of these games to be played, really, where claimants can make these claims when they own and control that enterprise on their own behalf for really what is indirect injury, bypass rights of creditors, and also get the opportunity to bring parallel claims because they're not waiving the rights.
Thank you.
Okay, now, Renco says that you can bring these types of claims for these indirect injuries, and they rely again on this Thornton article, and specifically the portion where she says that the NAFTA provision the waiver provision muddied the distinction between the claims that could be brought on the claimant's behalf and on the enterprise's behalf. So I want to just take a look at that, because if you look at slide 55, you'll see the issue. This is the waiver provision under the NAFTA. Article 1116, it says, a claim on behalf of the claimant can be brought where the investor, it says under B, and where the claim is for loss or damage to an interest in an enterprise of another party that is a juridical person that the investor owns or controls directly or indirectly. Sorry. Okay.
What line are you?
The red line under B, 1121 1B, right? It's saying here that an investor can bring a claim on its own behalf if the investor, and where the claim is for loss or damage to an interest in an enterprise that the investor owns or controls, the enterprise, if both the claimant and enterprise waive their rights, or it can be brought in two on behalf of the enterprise if both the investor and the enterprise waive their rights. So Renco looks at this and says, look, the type of injury that Mr. Landau was just talking about, where the injury is an indirect injury to the claimant because it's a damage to an interest in an enterprise, can be brought by a claimant on its own behalf. Now, this is what Ms. Thornton was referring to when she says that NAFTA muddied the distinction. And it did to some extent, because it said on the one hand, 1116 direct injuries, 1117 indirect injuries, and yet here it's seemingly allowing a claim to be brought by a claimant on its own behalf for loss or damage to an interest in an enterprise of another party. But in fact, that muddying of the distinction was corrected in the treaty. And let me just preface this by saying that Renco then relies on a number of cases under the NAFTA and says, you see, these types of indirect injuries, they were brought under 1116, and that was okay. Now, it is true that in the NAFTA cases, tribunals have not dismissed for lack of jurisdiction when the claim was brought under arguably the incorrect article, Article 1116 or Article 1117. But the reason for that, if you look at it, is because there were no practical consequences. It might have been essentially, almost like a typo, right? They wrote the wrong article, but if they were bringing this type of an indirect claim under the NAFTA, the enterprise also had to submit a waiver. So you didn't have the waiver problem, because in both instances, you're submitting a waiver on behalf of the claimant and the enterprise. If you're bringing it on behalf of the enterprise under Article 1117, you have a waiver. And if you bring it on your own behalf for your loss or damage to an interest in an enterprise, you have to submit the enterprise waiver. Now, then the only issue would arise if you were awarding damages to whom you have to award them. And again, as the Mondiv Tribunal stated, the tribunals could take care of that by directing their award to the proper claimant. And in fact, that has been the case. Now, our treaty removed this ambiguity because you can see here that it doesn't have the language saying that under the equivalent of 1116 that you can bring a claim for loss or damage to an interest in the enterprise that you own or control. It took that language out to make clearer the distinction between claims brought on the claimant's own behalf for direct injury and claims brought on behalf of the enterprise for indirect injury. Now, Renco's argument is that this language, taking it out, actually weakened the waiver provision. So claimants want you to believe that they can continue to make claims based on harm to their interest in the enterprise when the claimant owns or controls the enterprise. And the only change, what this change means, is that they now don't have to supply an enterprise waiver. Now, that's clearly not the case. As I just showed you with the United States' submissions, it's not the case. It's been the United States and Peru have been very clear that there is a difference between claims on the claimant's own behalf and claims for direct injury and those for indirect injury. And also, the treaty strengthened the waiver requirement, recall, because they limited the exceptions. Before, in the NAFTA, you could bring any claims except for, you had to waive your right to bring any claims except for proceedings for injunctive, declaratory, or other extraordinary relief not involving the payment of damages. In the treaty, it actually says you're limited to other proceedings for interim injunctive relief, and only those proceedings brought for the sole purpose of preserving the claimant's or the enterprise's rights during the status quo of the arbitration, during the time of the arbitration. So it makes no sense that the parties are actually strengthening the waiver requirement. They're limiting the exceptions to it, and yet Renco would have you read it as yet opening this huge hole to allow claimants that own or control an enterprise to bring claims for their loss or damage suffered to an interest in the enterprise and not supply that enterprise waiver. Okay.
I have one other
Yes.
question. As I understand that a key element in the submission that you're making is that it's a different situation when a party owns or controls,
Yes.
and therefore the minority shareholder situation is irrelevant for these purposes. That's a different considerations, including the awards on those cases.
That's correct.
That the language owns or controls one sees in 1016(1)(b). Where does one get the meaning that owns means majority or total ownership?
There's not, I don't believe that it's in the treaty, any definition, and so it's just evolved by jurisprudence as to what that means. I mean, clearly, it doesn't mean owns as have any ownership interest, because that would not make sense, because you can't supply a waiver if you own, a minuscule amount, so they don't mean ownership in that sense.
You could procure it. You might be able to procure it, even if you have minority interest. The problem is you can't necessarily do so.
You can't, exactly. So you couldn't be compelled to do so. You wouldn't be able to be foreclosed from bringing a claim because you were unable to voluntarily get a waiver from an enterprise over which you had no control. So in that sense, it might very well be one of those instances like loss or damage where there's no intended difference between those two words, although they're used in the disjunctive. And here, ownership or control, I think it has been interpreted by tribunals quite correctly to mean essentially control, that you are able to control and direct that enterprise.
You might not be able to do so now, but at some point it'd be quite useful to have any references to the
Yes.
jurisprudence that you have in mind.
Certainly.
Thank you.
And now, I think, can I just clarify, just for the record, for the time that the tribunal is asking questions, is that taken into account in the allocation of our time? Okay, thank you very much. And so now I just want to lastly address the third violation, which is the violation on account of the ongoing proceedings. And there are several claims, as the tribunal is aware, where claims have been dismissed where there were ongoing local proceedings. Some of those claims also involved non-complying waivers. Some did not. In some, the written form of the waiver was fine, but it was only the material aspect that was deficient. In others, it was both. So you know about, of course, Waste Management, Detroit Bridge, Commerce Group. There's also been a recent decision, KBR versus Mexico, a NAFTA claim, Gabrielle Kaufman-Kohler, Andres Rigo-Serreta, Gerardo Lozano on the tribunal, our friends at the other table, represented claimants in that case. Unfortunately, the case has not been published yet, but they are, again, dismissed for lack of jurisdiction, where the claimant was pursuing parallel proceedings. In that case, they were challenging in Mexico, Mexico's set-aside of a commercial arbitration award against a state-owned company, and at the same time, they were engaged in enforcement proceedings in other countries. Now, the ongoing proceedings at issue here violate the waiver requirement in two ways, and I'll speak about each of them. First, DRP violated its waiver that was submitted with the original notice of arbitration. Here, when you look again at the timeline, you'll see that with the original notice of arbitration, the waiver was submitted by DRP, and during that time, DRP's appeal of the amparo proceeding was continuing. So it did not discontinue that appeal at the time that it filed that waiver. And then it purported to withdraw the waiver several months later. So even if you take that withdrawal into account, during the several months period after it filed its waiver with the notice of arbitration until that waiver was withdrawn, it acted in violation of that waiver. And that's a clear violation of the waiver by DRP. Now, jurisdiction, again, must be considered at the time of the notice of arbitration and at the time of the first waiver, even if that's later amended. And I would draw the tribunal's attention again to the Detroit Bridge case, because there, the claimant filed a notice of arbitration along with the waiver. It then amended its notice of arbitration and filed a second waiver. And then it filed a further third waiver at the hearing on jurisdiction. And the tribunal, when it was determining whether it had jurisdiction, it looked at the first notice of arbitration and the first waiver to determine whether it had jurisdiction, because that is at the time at which jurisdiction needs to be seized. Now, claimants, Renco also argues in defense that the local proceedings are defensive and therefore not in violation of the waiver requirement. So this is separate and apart from the violation of DRP. Ongoing, as I've just discussed, DRP ought to have submitted a waiver with the amended notice of arbitration. And as you saw with Mr. Hamilton's timelines, both the amparo proceeding continued after the amended notice of arbitration was filed, and the second, what we're calling the administrative action, was commenced after the amended notice of arbitration was filed. And both of these proceedings were filed by DRP. So by its very nature, if you are initiating or continuing a proceeding, those proceedings aren't defensive in nature. Now, Renco relies on numerous cases in support of its defense, all of which are cases interpreting fork in the road clauses, all of which are in opposite. As an initial matter, first, a fork in the road clause is more narrow than a waiver provision of the nature that's found in this treaty, because a fork in the road clause focuses on the claims that are being submitted, where a waiver provision is broader because it's focused on the state measures which give rise to the dispute. And so just because a claim is found not to trigger a fork in the road clause doesn't mean that the same measures weren't at issue in the parallel proceedings, which would give rise to a waiver violation. And both the Detroit Bridge Tribunal recognized this, as well as the treatise by McLaughlin, which the Detroit Bridge Tribunal cites. Now, in some of those fork-in-the-road cases cited by Renco, the claims clearly are defensive. The claimant in that case is the defendant in the local proceedings. In others, the tribunal seems to suggest that there was some type of maybe economic duress, in essence, that they seem to be saying you had no real choice. And what they're looking at, what seems to be motivating them in basically, I think, the Occidental case and perhaps the Chevron case, is that there was a very short time period under the local law. And if the claimant had not made the choice to bring the local proceeding, that local measure would have become final, and they thought it was, in essence, unjust then not to foreclose the claimant from proceeding in arbitration. First, to the extent that that's what any of those tribunals have done, you can't override a treaty requirement that goes to the issue of consent with perceived equitable considerations. But those same considerations in any event don't apply here, because we're not faced with a fork-in-the-road clause. Claimants were not faced with a choice as to what do I do. I have a short time period, allegedly, to challenge the MEM's credit in Peruvian courts. Do I do that or do I go to arbitration? This treaty has a no U-turn provision. It could have pursued those claims and then later initiated arbitration, or it could have foregone pursuing those claims and just went to arbitration. And the waiver and the no U-turn provisions, like I said, work hand in hand. Renco argues in its rejoinder that if the United States and Peru had really wanted to encourage resort to local courts, as we say they did, they would have added an exhaustion of local remedies requirement, but instead they added this 3-year prescription requirement. Again, Renco is mistaken here, because the parties did want to encourage resort to local courts. They did not mandate resort to local courts, and in fact, they incentivized local courts to administer the proceedings efficiently by placing this 3-year prescription period, which might render moot complaints that would later be brought to international arbitration. And Ms. Tovar, as you'll see, will later describe in a bit more detail why these actions, again, under Peruvian law, don't fall within the exception. Notably, Renco, in its rejoinder, says that DRP and the liquidator now were powerless to stop the bankruptcy proceedings. But what they don't say is that DRP or the liquidator were powerless to discontinue the administrative proceeding or the amparo action, because that simply is not the case. Whether they could have stopped the bankruptcy proceeding is irrelevant. What we're talking about are these parallel local proceedings. In addition, Renco argues that, well, these local proceedings don't matter, they won't result in double recovery. Again, that's not the only objective of the waiver provision. And in fact, the RDC tribunal recognized this because they noted the waiver provision doesn't only preclude claims for damages. It covers more than that. The exception says that you can't pursue claims for damages. You can pursue, certain claims that are not for monetary damages, provided that the sole purpose is to preserve the rights during the pendency of the arbitration. And that language would have been unnecessary if the waivers were only intended to preclude other claims that could result in damages claims against the state. And again, our treaty is broader than the NAFTA in this respect. And finally, the very last small point that I want to make is that Renco then argues, in any event, even if these local proceedings are a violation, it would only result in the dismissal of a very small portion of the claim. Again, Peru disagrees. Because this is a condition of consent to arbitrate, all of the claims should be dismissed. The tribunal, as I discussed earlier, cannot permit Renco to remedy its claim by submitting a new waiver, and by the same token, it can't permit Renco to remedy its violation by carving out measures that are currently covered by its waiver. which is in essence what it would have to do to continue the Peruvian action and maintain its claim here. Renco could have filed a more limited claim in this arbitration, one that just covered the St. Louis lawsuits, for example, and maintained the bankruptcy, the challenge to the MEMS credit in the bankruptcy proceedings in Peru, but that's not what it did. And if you look at the Methanex, the very last slide here from Methanex, in that case there, the claimant sought to amend its claim after the proceedings had started. And one of the problems with that was they wanted to challenge new measures. Those new measures, it was found, could not possibly be covered by the waiver it had submitted, because the waiver has to be interpreted at the time of the notice of arbitration. It couldn't be interpreted to cover new measures. By the same token, the measures that are being challenged in the local proceedings are the same measures that are being challenged in the notice of arbitration. So you can't withdraw those claims to retroactively rewrite the waiver any more than the tribunal could accept from Renco a new waiver at this juncture, or any more than the Methanex tribunals could interpret the original waiver to cover new measures that were not in the notice of arbitration. And so with that, I will turn the floor over to Ms. Tovar. Thank you.
Sorry, just before, forgive me, I'm going to make myself perhaps even more unpopular by just asking a question out of order. Forgive me. Can I take you, I'm sorry about this, can I take you back just to the discussion that we had on direct and indirect, just before you
Yes.
pass the baton on? I'm just wondering whether you have any observations to make on the text of Article 1016(1)(a) and B. That the dichotomy that you've developed is between direct loss and indirect loss. And those would be losses, in essence, I may be unfairly summarizing it, but losses to the party in Renco's position. So Renco suffers either direct loss or it suffers indirect loss. Mm-hmm. And the question I still have in my mind is, why then in the language was the phrase "on behalf of" used? Because one might read this as saying that it's not different types of loss to a party in Renco's position. It's on the one hand loss to a party in Renco's position, and on the other hand loss to a party in DRP's position. And that would perhaps explain the language "on behalf of," and also the language in A2 and B2. A2 that the claimant has incurred loss or damage, and B2 that the enterprise has incurred loss or damage. I don't know if that was clear, the way that so what I'm just asking is whether or not you feel there's anything you want to add or to explain why that language is framed in that way.
I believe that the reason why it's framed that way in the little b is to resolve what the parties have referred to as the Barcelona traction problem, which is in that case, the harm that was, the claim was being brought, if I recall correctly, by a shareholder of the company. And the harm at issue was harm that was to the company itself, but the shareholder obviously had suffered a loss as a result of the measures that were directed towards the company. The company itself didn't have the right nationality to bring the claim, and the shareholder was bringing the claim. And the court in that case said, no, you have to maintain the distinction, the juridical distinction between the shareholder and the corporation. And this is properly a claim on behalf of the corporation. You look to national law for that. And the corporation thus would need to be the claimant and have the proper nationality. In the investment treaty context, the parties wanted to, or recognized that claimants would often not invest directly, and directly own an asset in the host country, but rather would establish a local enterprise that would hold the assets in the country, and that the measures then could be taken against that local enterprise, but that local enterprise wouldn't have standing to bring an international claim because it wouldn't have a nationality different from the host state. Now, ICSID takes care of that in some respects, allows in certain circumstances for those entities to be considered to be nationals of the foreign owners. But the parties to the United States' treaties, beginning, well, at least with the NAFTA, it may have predated that, the way that they, or I think the NAFTA was the first one, the way that they took care of it was to still maintain the distinction between a direct claim to a company and a direct claim to a shareholder, but to allow the claimant to recover for injuries that it suffered as a result of measures that were directed to the enterprise by saying that the claimant could bring the claim on behalf of the enterprise. So it's in essence stepping into the shoes of the enterprise and bringing that claim on its behalf when the enterprise couldn't be named as the claimant because it doesn't have the right nationality. So I believe that's the origin of that language, was to resolve that issue.
Thank you very much.
I will speak in Spanish.
We're going to take the following minutes to address the two local proceedings we have been talking about from the point of view of Peruvian law. That is, we're going to see how these proceedings are described and what is their scope in accordance with Peruvian law. The first thing I would like to stress is that neither local proceeding can be characterized as an injunctive relief. In either case, when we talk about the amparo action or when we talk about the administrative action, can we state that either one is an injunctive relief? Both, and first I will speak about both, and later on I will focus briefly on each one, but both are proceedings whereby a material final decision is sought on the merits and regarding the facts. In both cases, both in the amparo action and in the administrative law action, the decision that is sought from the court regarding the complaint is a final ruling, and it is not interim, and it doesn't try to ensure the outcome of any future decision. And in neither case, an injunctive relief was sought. We are going to make a distinction between these two material proceedings, which, as usual with any legal proceedings in Peru, can be accompanied by the request for injunctive relief. In both proceedings, that is both in the amparo action and in the administrative law action and under arbitration treaties, you can seek injunctive relief, which are regulated by rules that are separate from the proceedings, and in neither case, injunctive relief was sought. Additionally, we would like to point out that in both cases, these are autonomous proceedings. They're separate. They're different from the bankruptcy proceeding, from the administrative bankruptcy proceeding. In both cases, as my colleagues have said, an action was brought voluntarily before the court by Doran, Peru. Therefore, these are not defensive actions. These proceedings were brought voluntarily by a claimant, that is Doran, Peru. And in both cases, they have been litigating before Peruvian courts, that is the judiciary, which has its own organization, which is different from the administration. And in both cases, they're regulated by special laws. Laws are different from laws that govern bankruptcy proceedings it's a separate law, and they have separate proceedings and separate instances. Now I'm going to focus briefly on each proceeding. The first local proceeding is the constitutional proceeding called amparo action. Amparo actions seek to protect constitutional rights. These proceedings are judicial proceedings that are contemplated in the Peruvian Constitution, and they're governed by a specific law, which is the Constitutional Procedural Code, Law 28237. If we go to Section 1 of the Constitutional Procedural Code, we see that what constitutional proceedings, including amparo action, seek substantive decision to restore constitutional rights that a party believes that have been violated. So what is sought? They seek to remedy a constitutional violation. If we go to Section 55 of the code, we will see what the decision entails in these proceedings. The court's decision in these cases of amparo action contain a final opinion on a violation of the Constitution. For example, and this is seen in Section 55, they can annul the act that is the object of the claim. As we can clearly infer from the regulations, the decision is not something temporary that it can affect other proceedings. It's a final and material pronouncement. At any rate, as I had said, while this substantive proceeding is ongoing, you may request what we call injunctive relief. This is in Section 15 of the Constitutional Procedural Code. It establishes that you can seek, in parallel to an amparo action, an injunctive relief, the same way that you can request it for any substantive legal proceedings or arbitration. As to the administrative law case, that is a second proceeding, the administrative law case starts with a claim that seeks total or partial annulment of an administrative act. This proceeding is contemplated in the Peruvian Constitution. You can bring administrative law actions against any final act by the administration. You can always go to Peruvian court and bring a claim against an act by the Peruvian administration. And this happens as well in bankruptcy proceedings. So this administrative law action has that purpose. It is not correct to state that this is an injunctive relief. This is not an injunctive relief. It solves a substantive problem, and it provides a final decision. And in the same way as the amparo action, you can seek injunctive relief as long as the administrative law action is ongoing. You can obtain an injunctive relief to to suspend the effects. This has not happened in the amparo action or in the administrative law action. On the other hand, the administrative law proceeding is separate, is autonomous. it is not, as claimant says, a simple appeal or continuation of bankruptcy proceedings. We have cited authorities that explain the nature of this initial proceeding, and the legal authorities state that the administrative law action is not a remedy, rather is a full judicial proceeding with parties that are seeking the protection of their rights in an administrative law case. There's a question and answer paper on bankruptcy proceedings that was submitted by claimant, which is not in conflict with the statements by the legal authorities and that I have mentioned. Renco, in its reply in paragraph 80, mentions a note that was included in the notification of the Indecopy Tribunal, that is this administrative decision by Indecopy Tribunal that recognized the credit with the Ministry of Energy and Mines, which is still being challenged both in the amparo action and the administrative law action. In this note, it says that the decision by the Indecopy Tribunal enters into force as of the date of its notification, and thus the administrative law is exhausted, and it adds that it could be the matter for an administrative law case depending on the applicable law. Renco interprets this to mean that the administrative law appeal is a continuation. This is not correct. What this paragraph indicates is that the credit verification process has concluded, and therefore it says that the administrative proceedings have been exhausted. And this is the opposite of what Renco states. What the note says is that the administrative law proceeding has ended. The fact that you can bring this to a court, as you can do with any administrative act of the Peruvian government, does not mean that it is a continuation of the administrative law case, but rather this is a judicial proceeding. To summarize, as to the two local proceedings, their nature under Peruvian law does not fit the exemption in the treaty for the waiver, as my colleagues have stated. So now I will pass the floor to Jonathan Hamilton.
With leave from the chair, if I may, before we leave this lecture on Peruvian law, my question is addressed to all members of the Peruvian legal team. If there are issues of Peruvian law which could control to some extent our decision, wouldn't the tribunal be well advised to call for expert evidence in the fullness of time on both sides in order to fully understand what the Peruvian law issues are?
Thank you very much for the question, Mr. Fortier. Peru is advised on this matter by Peruvian counsel, which appears on all of our briefs and has fully briefed this issue. Renco, I believe, is not indicating on its briefs advice of Peruvian counsel and has not chosen to submit any such request. And as a matter of due process, Peru is comfortable that each party has been able to plead its Peruvian law arguments with respect to the nature of these proceedings.
May I just note for the record that respondents have now spent 1 hour and 45 minutes after deducting questioning time from various members of the tribunal. So perhaps I could ask you now, how much longer do you intend to be, so we don't run over too much?
I could conclude in 5 minutes.
I can see by your
That's
slides that
acceptable.
you're towards the end, about to
Yes.
wrap up. I think if we could move in that direction, it would be helpful. But first, let me thank counsel very much for those helpful remarks. Gracias. All right, Mr. Hamilton.
Thank you very much, and thank you, members of the tribunal, for the questions that you have raised with us. Brief words of conclusion regarding the context and consequences of Renco's treaty violation. First of all, this objection is before the tribunal pursuant to Article 23 of the UNCT arbitration rules regarding pleas as to the jurisdiction of the tribunal. In that clause, of course, there's no requirement of urgency. There's no urgency prong, as one might find, for example, in a provisional measures proceeding, and Peru considers it inapposite that Renco continues to insist on an issue of urgency. And in any event, as the treaty itself makes clear, the waiver requirement is absolute, and the obligation of the tribunal to resolve that absolute requirement is also clear and plain. To reach a determination on this objection, the tribunal has all that it needs in the plain facts regarding the existence of these local proceedings and their relationship to the treaty arbitration. And again, I direct you to Peru's Memorial Annex A, setting forth those basic facts. Now, if one takes those facts as to the relationship between the local proceeding and the treaty, of course, one could discuss a long and broad historical context related to La Oroya. And in fact, it appears to be Renco's desire to try to take a selective piece of that, or try to suggest that there is a long and complicated factual issue before the tribunal, or at least a little selective piece that Renco wishes to put before the tribunal to obfuscate its violations. Suffice it to say, and as indicated on the diagram at page 70 of our presentation, the core facts of this case predate the entry into force of the treaty between Peru and the United States. In fact, from the date of the underlying contract in 1997 to 2009 was a critical period of time in terms of La Oroya. As indicated on page 71 of our presentation, and this is drawn from figure 2 of Peru's submission of October of 2014, it was during that period of time, prior to the entry into force of the treaty, that Renco and DRP made certain undertakings, including the undertaking to comply with an environmental program, something which has never been completed despite cooperation by Peru. And it, of course, was in that context as well that Peruvian citizens chose to file a still pending U.S. litigation against Renco and other parties, all before the treaty entered into force. Now, Renco is trying to suggest that certain things that happen in connection with the bankruptcy proceeding, restructuring and liquidation scenarios of DRP are critical and complicated, et cetera, but it really is not that complicated. As a matter of fact, if we could go back for a second to the historical slide, what one really notices here is that the cornerstones of their claims all predate the treaty, and the rest appears to still be in motion and perhaps not even be ripe under the treaty. You don't have to get into all of this, members of the tribunal, because the fundamental violation of the waiver requirement is all you need to know that Renco's arbitration notice is defective, is impermissible, and vitiates the consent of Peru and the jurisdiction, the capacity of the tribunal to seize jurisdiction. As a matter of fact, let's take a look briefly on slide 72 at how these local proceedings fit into the overall scheme of what seems to be going on by Renco and Do Run Peru. As I mentioned in my opening comments, the treaty arbitration, as soon as the notice of intent was filed, Renco promptly used the existence of the treaty notice of intent in U.S. courts as part of its defense. As a matter of fact, on January 7th, 2001, and you can see in the record document RLA 35, that Renco removed proceedings to federal court on the basis of the arbitration at that point in the stage of the notice of intent. Meanwhile, Renco, through DRP, set about local proceeding 1 and subsequently local proceeding 2, but never disclosed the existence of the treaty case there. Renco wants to have as many bites of the apple as it can to try to benefit itself, but the treaty simply does not permit this kind of conduct. And that's why the parties to the treaty, Peru and the United States of America, agree on the consequences. And it's summarized at the conclusion of the United States submission to the tribunal of yesterday, which makes it clear that a failure to satisfy the waiver requirement, both through formal, absolute written submission and by failure to conclude ongoing proceedings or by starting local proceedings, vitiates the consent of the state. It is an absolute requirement binding on this tribunal. A claim can be submitted and the arbitration can properly commence only if a claimant submits an effective waiver. Here, Renco and DRP have not submitted effective waivers. In addition, the conduct in the local proceedings constitutes a further and material violation of this requirement. For all of these reasons, Peru respectfully requests a ruling from the tribunal in favor of the Republic of Peru. Thank you for your attention.
Thank you very much, sir. Yes, Mr. Fortier.
If I may, thank you, Chairman. Mr. Hamilton, you have alluded in this last argument to Article 23 of the UNCTAD rules. After the first meeting of the tribunal with the parties in 2 years ago, in the summer of 2013, there were discussions and negotiations between the parties which led to Procedural Order Number 1 and the annex thereto. And then there were submissions made to the tribunal, which led to our decision of December 2014, wherein we said specifically in paragraph 256 that the respondents' other preliminary objections which related to competence may be brought by the respondent together with its counter-memorial on liability in accordance with the timetable set out in Annex A to Procedural Procedural Order Number 1. And then in early this year, you represented to us that there was an urgent need for the tribunal to take up Peru's waiver objection as soon as possible. And on the basis of your representations that there were new and allegedly important events in the local involuntary bankruptcy proceedings ongoing since 2010, that there was an urgent need to have the tribunal deal now with this waiver objection, which clearly goes to competence. I'm curious to know what are those urgent, new and allegedly important events that have occurred in recent months, Mr. Hamilton?
Thank you for your question, Mr. Fortier. In the first instance, I believe that the characterization of urgency did not originate in our request to the tribunal of April of 2015. It is something that was mentioned in a subsequent ruling of the tribunal and has been seized upon by our friends. I have a couple of observations. First, Peru, as noted at the outset of our arguments, flagged this issue promptly at the outset of this matter, which was then stayed by agreement of the parties. The constitution of the tribunal was suspended for an extended period of time, number one. As Ms. Menaker has explained, that has not been unusual in other cases involving waiver issues. Second, Peru promptly raised its objection in good faith based on Peru's understanding and interpretation of Article 1024 of the proceeding, and Peru submitted contemporaneous evidence, documentation by a participant in the negotiations of the treaty as to why it could bring that argument at that time. Third, Peru learned in April of this year that Renco's subsidiary had taken new movements in the second local proceeding. And it is our view that Renco perhaps freed of the scenario of an argument before the tribunal with respect to this waiver issue, then was trying to seek a ruling before the tribunal would ever hear it. And so Peru brought this diligently to the attention of the tribunal and again requested a ruling under UNCT Article 23. And so that is the clear steps that Peru diligently took. And in any event, we would underscore again that there's no out from this waiver requirement. The waiver requirement is absolute as set forth in the treaty. Thank you very much.
All right, ladies and gentlemen, excuse me, we've now come to the time for our break in accordance with our schedule. Just to recap, respondents' time thus far is 1 hour and 55 minutes. So let's follow our schedule and take 15 minutes now and then come back with the claimant.
Thank you, Mr. President.